Am I entitled to double pay on holidays? Picture this. It's Thanksgiving Day or Christmas, and instead of being home with family, you're scheduled for an 8-hour shift. As you clock in, you wonder, am I legally entitled to double pay on holidays? Many workers assume holiday shifts mean double time. Employers sometimes encourage that belief, but the truth is more complicated. Federal law does not guarantee double pay on holidays. Whether you get it depends on a mix of wage laws, state rules, company policies, and collective bargaining agreements. In this video, we'll break it all down step by step. We'll explain what the Fair Labor Standards Act, FLSA, says, how overtime works if a holiday pushes you over 40 hours, which states require premium holiday pay, and when contracts or unions make double pay enforceable. By the end, you'll know exactly when you can expect extra pay, and when it's just a workplace perk. Federal law, the FLSA, and holidays. Let's start with the basics. The Fair Labor Standards Act, FLSA, sets the federal rules for minimum wage and overtime. But here's the surprise. The FLSA does not require employers to pay extra for holiday shifts. That means no federal law guarantees double pay on holidays. Employers must pay at least the minimum wage for all hours worked. Overtime at time and a half applies if you exceed 40 hours in a work week, whether or not the hours include a holiday. Example: if you work 32 hours Monday to Thursday and then an 8-hour shift on Christmas, your total is 40 hours. No overtime is owed, and the FLSA does not require double pay. But if you already worked 40 hours and then do another 8 on Christmas, you are owed 8 hours of overtime, at least time and a half. So under federal law, the holiday itself doesn't trigger double pay. Overtime rules do. State laws and exceptions. Some states go further and require premium pay for certain holidays. Massachusetts. For many years, blue laws required premium pay, often 1.5x, for certain retail workers on Sundays and holidays. These rules have been phasing out, but in some cases, employers still must pay extra. Rhode Island requires premium pay for most employees who work on Sundays and certain holidays. California and New York do not require holiday pay by law, but strong wage and hour protections apply if overtime is triggered. Puerto Rico has special holiday premium pay requirements under local law. Example: a retail employee in Rhode Island works on New Year's Day. The employer must pay premium rates even if hours don't exceed 40. The key is state law. Most states follow federal rules and don't mandate extra pay, but a handful still do. Employer policies and handbooks. Even if not required by law, many companies offer holiday pay as a perk to attract and keep workers. Some pay time and a half for holiday shifts. Others pay double time. Some add holiday bonuses or floating days off. If it's written in an employee handbook, contract, or offer letter, it becomes enforceable. Employers can't promise double pay in writing and then deny it. Example: a company handbook says employees who work on Thanksgiving get double pay. Even though not legally required, once promised, workers can enforce it. Union contracts and the NLRA. Unionized workers often have stronger protections. Collective bargaining agreements frequently guarantee premium holiday pay. Some contracts provide double pay plus a paid holiday. Others rotate holiday shifts fairly among employees. Employers must negotiate with unions over holiday pay terms. Example: a union contract at a grocery chain requires double pay on Memorial Day. Workers who clock in are legally entitled under the agreement, enforceable through the National Labor Relations Act, NLRA, religious holidays, and Title VII. Another angle is accommodation for religious holidays. Under Title VII of the Civil Rights Act, employers must reasonably accommodate religious observances unless it creates undue hardship. This doesn't mean automatic pay increases. It means employers must consider schedule swaps, unpaid leave, or alternatives. Example: a Muslim employee requests time off for Eid. The employer denies and instead schedules them to work but pays normal wages. Title VII requires reasonable accommodation but not double pay, so religious rights affect scheduling, not pay rates. Practical realities, industry by industry. Holiday pay practices vary across industries. Retail and hospitality. Holiday shifts are common. Many employers pay extra as policy, but it's not legally required. Healthcare. Hospitals often run 24/7. Holiday differentials are frequently included in union contracts. Public sector. Many government jobs include guaranteed paid holidays or premium rates by statute or policy. Gig work. Apps like Uber, DoorDash, or Instacart may offer holiday surge pay, but these are incentives, not legal requirements. Example: a nurse in a hospital with a union contract may receive double pay for Christmas. A grocery cashier in a non-union store may only receive standard wages unless state law or company policy says otherwise. Overtime scenarios on holidays. The most common legal protection for extra holiday pay is actually overtime. If a holiday shift pushes you over 40 hours in the week, you get time and a half. If your employer already offers holiday pay, that's in addition to overtime. Employers cannot average 2 weeks to avoid paying overtime. Example: a warehouse worker clocks 48 hours the week of Thanksgiving. The 8 hours on the holiday must be paid at time and a half, even if the company doesn't have a holiday pay policy. If the company does offer double pay, those benefits stack. Common misconceptions. Workers often believe federal law guarantees double pay. False. All states require holiday pay. False. Only a few do. If I work on Christmas, I get overtime. Not unless you exceed 40 hours. Holiday pay is always optional. False if promised in contracts or required in union agreements. Clearing up these myths helps workers know what to expect and when to push back. Real-world cases. Case 1. A Rhode Island retail worker successfully claimed premium holiday pay under state law after being denied. Case 2. Employees in Massachusetts challenged an employer that ignored Sunday premium pay rules and won back wages. Case 3. A unionized hospital enforced double pay on holidays through arbitration under its contract. Case 4. A grocery store promised holiday pay in its handbook. Workers sued when denied, and the court enforced the handbook as a binding policy. These cases show that while federal law is silent, state laws, contracts, and promises can carry real weight. The bigger picture. Holiday pay is a mix of law, policy, and bargaining power. The FLSA sets the floor, minimum wage, and overtime, but doesn't create holiday-specific rules. States like Rhode Island and Massachusetts add requirements. Unions negotiate premium rates. Employers often use holiday pay as a benefit, but once promised, it must be honored. For workers, the key is knowing which rules apply where you live and work. Don't assume double pay is automatic, but don't ignore enforceable promises either. So, are you entitled to double pay on holidays? Under federal law, no. The FLSA guarantees minimum wage and overtime, but not special holiday rates. However, if holiday hours push you over 40 in a week, overtime at time and a half applies. Some states, like Rhode Island, require premium pay. Union contracts and company policies can also guarantee double time or bonuses. The bottom line, holiday pay is often a matter of state law, union power, or employer policy, not federal mandate. If your handbook, contract or union says you get it, you're entitled. Otherwise, standard wages apply unless overtime kicks in. If this video cleared things up, share it with coworkers. The more we understand holiday pay rules, the better prepared we are when holiday shifts come around.